Hello, my name is Indy Carlisle, and today we'll be talking about Burwell versus Hobby Lobby. On September 12, 2012, Greens, as a representative of Hobby Lobby stores, sued Kathleen and the Secretary of the Department of Health and Human Services and challenged the contraceptive demand. The plaintiffs argued that a requirement that an employment-based healthcare system set up a birth control prevention profaned in the Free Exercise Clause of the primary modification of the Spiritual Freedom Restoration Act of 1993. The plaintiffs sought a preliminary injunction to stop the social control of tax penalties, which the district court denied, and two-judge panel of the U.S. Court of Appeals for the 10th Circuit affirmed. On this day, the Supreme Court also denied the relief, and the plaintiffs filed for a hearing of the Court of Appeals. The panel of the Court of Appeals reversed and commanded that the companies were persons for the functions of the RFRA and had protected rights beneath the Free Exercise Clause of the primary modification, according to Visconti in 2017. If one company provides contraceptives, should all companies provide that? The Religious Freedom Restoration Act protected religious liberty by less restrictive freedom by the government, offering companies cost-effective ways for contraceptive covering by being paid for by the insurance company providers, but by the employer. Do you think that women have the constitutional right to be able to have birth control rights as well as rights to abortion? They do, but on constitutional rights that they possess, some other persons get it. So is this bias? The question is, the Hobby Lobby case was whether the government will force some other person to get women's contraceptives despite the fact that one person has the spiritual objections by doing therefore. The decision, Justice Ginsburg argues, disregards the beliefs and needs the employees and their dependents, supporting the beliefs that one group of people behind a corporation and its owners can be harmful to other people, creating a fundamental principle of conflicting rights. So what's the credibility in this? The generalization that was Visconti of 2017 found that under the ACA's contraceptive command, the proprietors and the side interest campaign were constrained to a situation, either finance or questionable contraceptive strategies, and demand that their devout concisions or pay up to $475 million in punishments and stay steadfast to their beliefs. 5 individuals of the 9-member court concurred that the order went as well far, and 4 contradicting judges said that the command was not coercive or devout convictions, since it was required to devout proprietors to bolster a well-being protections program, since it would be up to each representative to choose which administration to select. The owner's proportion that the choice was well constricted and trigger any devout protections. According to CS Monitor in 2014, the court ruled on June 30th that the owners of the closely held profit-making corporations cannot be forced under the Affordable Care Act, nor to provide the employees with the certain kinds of contraceptives that offend their religious beliefs. The decision arose from the litigation filed by the owners of the national chain of craft stores called Hobby Lobby, and the owners of Conestoga Wood Specialties, a cabinet maker in Pennsylvania. It has sparked a heated debate concerning the scope of non-secular of liberty within the United States and whether or not bosses are currently authorized to impose their religious beliefs or on their own workers. It has also raised an issue that veteran staff can currently be denied access to contraceptive. So what is your viewpoint? Which viewpoint do you stand on? As for me, I believe that each person or woman should have the access to birth control. But that doesn't necessarily need to come from your employer or your boss. I mean, you can go to a Planned Parenthood and receive free or little to nothing as far as contraceptive goes. The employers do not need to be treated like people. And when they do, they think it's where you have blurred lines. So if you start treating companies like people, can you say they can or cannot do something? What is your viewpoint on that? Because I feel like when you have a company and you start treating them like a person or a well-being, they're subjected to live by those specific means. And that's how you get blurred lines. So for me, I could go either way. but I still feel like I stand on the grounds as far as I think what the decision was the correct decision.